Hello friends, good day to you all. Today we are going to see what is an insurance contract, how to understand the various features of an insurance contract. When you buy insurance, essentially what's happening, you are entering into a contract with the insurance company. That is, you are offering your risk to the insurance company for a consideration, and the insurance company evaluates the risk offered by you, and depending on their evaluation, they may accept the risk or reject the risk. When they accept the risk, then an agreement comes into existence between you and the insurance company, and the insurance company issues the insurance policy that evidences the existence of contract between you and the insurance company. So essentially, insurance buying involves a contract between you and the insurance company. When we say a contract, it has to it has to have the various features as mentioned in the Indian Contracts Act 1872. So it lists various features that the agreement should have for it to become legally enforceable. Okay. Now, what does the Contract Act of 1872 says about a contract? Let's see. First, it defines contract as an agreement enforceable by law. It means all contracts are agreements, but all agreements need not be contracts. If the agreement does not follow certain features of the Contract Act, then it cannot be enforced in a court of law, and it ceases to be it cannot be called a contract. So all contracts are essentially agreements, while all agreements are not contracts. This is the first aspect of the Contract Act. The second aspect is, now here what we have said is an agreement. Basically, a contract is an agreement enforceable by law. But what is an agreement? This Contract Act also says what is an agreement. An agreement as every promise and every set of promises forming the consideration for each other. That is, when two parties are entering into an agreement, both the parties make promises to the other party. What promise? There will be a consideration. That is, I will do this, I promise to do this and this, and I promise to give you this and this to you in consideration for what you have to do for me. That is, both the parties make promise to each other. So the agreement essentially involves set of promises. When there are no promises, there is no agreement. Now we come to the issue of promise. This promise also defined in the Contract Act. What it says: a promise as a proposal, when accepted, becomes a promise. That is, when one party makes a proposal and when the other party accepts the proposal, a promise comes into existence. It's a promise. So essentially, promise involves a proposal and acceptance. When somebody makes a proposal and the other party does not accept, there is no promise, right? So what we have seen based on the Indian Contract Act, there are three things. That is, a contract is essentially an agreement enforceable by law. An agreement involves set of promises, and the promise involves offer and acceptance. So from this, two very essential features of contract come into existence. That is, offer and acceptance, and secondly, consideration. So for an agreement to become a valid contract, we have seen the two essential features are offer and acceptance and consideration. We will see what is offer and acceptance. When you are, say, buying a house, what happens? The seller makes an offer to you. That is, I'll give you a house with so and so specifications for so and so price. It's an offer. Now you evaluate this offer and see whether the house is suitable for your requirements, whether price is affordable, whether the price is right. All these things, you are evaluating the offer. After evaluating the offer, what you do? Either you accept the offer or reject the offer. It's up to you. When the seller made an offer, you evaluate the offer, you either accept or reject. When you accept, an agreement comes into existence. When you reject the offer, there is no agreement, there is no contract. So when you accept the offer, what is happening? Two sets of promises are coming into existence. That is, the seller is promising to give you a house, a dwelling place with certain specifications for a specific price, and you are agreeing to take that house by paying accepted price. So the offer is made by the seller. As a buyer, you have accepted the offer. So now there is an agreement, and the agreement becomes a contract. But in case of insurance, there is a difference. It's very important to understand this. In case of insurance, it is just reverse. The insurance company selling insurance cannot make the offer. The offer to transfer the risk, the offer to buy insurance is made by the buyer here. That is, the person who is trying to buy insurance makes the offer to transfer his risk to the insurance company for a specific consideration of premium. Now, how this offer is made? The offer is made by the person buying insurance through a proposal form. That is, he makes a proposal to the insurance company describing the risk he is offering to the insurance company. Now, it is up to the seller in this case, that is the insurance company, to evaluate the proposal and see whether the risk is acceptable to them or not. In case the risk is acceptable to the insurance company, they'll accept the proposal to buy the insurance and issue the insurance policy. In case the insurance company feels that the risk is not acceptable to them, they can decline to sell the insurance. So it's up to the insurance company to accept or refuse the proposal, whereas the buyer makes the proposal in this case. This is the basic difference between all other commercial transactions and insurance buying. This is the reason why it is said generally insurance is a subject matter of solicitation by the buyer. By the buyer is eliminated, but it is generally said insurance is a subject matter of solicitation. It is to be understood that the insurance company cannot sell insurance on its own unless the buyer makes a proposal to buy it. So the implication is that the insurance company cannot sell insurance without obtaining a proposal form. Now, it's very important to understand that this proposal form becomes an essential part of the insurance contract. This is the reason why all the insurance buyers should seek a copy of the proposal form from the insurance company and keep it in their record. Because when the question goes to adjudication, if in case of any dispute with the insurance company, when the issue goes for adjudication to a court, the proposal form forms a basic evidence of what information was given at the time of a risk transfer. In the absence of a proposal form, it becomes very difficult to prove that what material information was given, what was not given. It becomes very difficult, and it is to the disadvantage of the insurance buyer. It is therefore advisable to keep a copy of the proposal form as acknowledged by the insurance company. So, when we say offer and acceptance as one essential feature of a valid contract, the proposal forms in case of insurance become a very vital document. The second important feature of a valid contract, as we have seen, is consideration. Consideration we have already seen, that is the value proposition for each party. That is, when you are buying a house, the house is the consideration for the buyer, that is value proposition to you, and the consideration for the seller is the amount paid for buying the house. So both the parties have value consideration, right? Now, in case of insurance, the premium paid by the insurance buyer is a consideration for the insurance company, and consideration for the insurance buyer is what? It's just a promise made by the insurance company to indemnify under certain conditions. Just a promise alone happens to be consideration here, because if the event doesn't happen, if the condition is not met, the insurance company will not indemnify the insured. It will indemnify only when the particular event, insured event happens, and when the condition is met, then only indemnification takes place. Now, the promise alone happens to be the consideration for the insurance buyer. Now, there is one important thing. Okay, when after paying premium for a few years, if the premium is not paid, renewal premium is not paid, what happens to the contract? Generally, when the first premium is paid, it is considered as good enough consideration for the contract to come into existence. But what happens after 2-3 years, the premiums are not paid? What happens to the contract? The contract does not become void. Contract still exists. What happens is the insurance company will be absolved of its liability to indemnify. That is, it doesn't, even if the event happens, the insurance company is not obliged to pay any amount to the person. Okay? But when the liability ceases to exist, what will survive? See, the contract may have certain features as surrender value, paid up value, or revival. Because see, when premiums are discontinued, the policy will lapse and then the liability ceases to exist, but the contract still continues. Because of that reason, the policy can be revived by paying premiums and then penalty and whatever it is, whatever is required to be paid, the policy can be revived. The policy can be considered as paid up. There are other features. Okay, so paying the first premium is very essential for the contract to come into existence, and paying premiums continuously as required by the contract is essential for keeping the liability of the insurance company going. So this consideration is very important feature, because see, when somebody offers you something for free, okay, when he is giving you something for free and when there is no consideration for him, actually there is no contract. It's not a valid contract. Because when somebody offers you for free, if he doesn't give you that, you cannot go to court and then file a suit on him that he said he will give me free and then he has not given. So it doesn't, because there is no contract as such. So this is the reason many a time when you buy consumer durables, the billing is done for 1 rupee. 1 rupee, when they say free, they don't give it free. It is billed 1 rupee, they bill. So that means the consideration 1 rupee makes the contract valid, because it does not say how much money. It only says there should be consideration. The consideration in this case is 1 rupee. So the contract becomes valid. So the consideration forms the second important aspect of the valid contract. Contract Act 1872 further goes to define what is a contract, when an agreement becomes a contract. It very clearly says? It says all agreements or contracts, if it's made by the free consent of the parties competent to contract for a lawful consideration and with a lawful object and are not hereby expressly declared to be void. Very clearly it states the various features that the agreement should have for becoming a valid contract. So what is that? All agreements or contracts if it is made by the free consent of the parties. Free consent is one feature. Okay, after offer and acceptance and consideration, free consent is the third feature. Then parties competent to contract. That is, parties should be competent to enter into a contract. This is another feature. Next, the consideration should be lawful. Competent to contract for a lawful consideration. Consideration should be lawful. Right. The next one is object of the contract should be lawful. Lawful object. The next is the agreement or contract should not be declared void by law. Then the agreement becomes a legally enforceable contract. First we will see what is free consent as an essential feature of contract. Free consent means absence of coercion, undue influence, fraud, misrepresentation or mistake. Okay? You cannot force a person into a contract through coercion. What is coercion? Let's say in insurance contract. Suppose a lady is an agent, insurance agent, and her spouse happens to be a very senior police official. Okay. Now, this insurance agent cannot use the power of her spouse for forcing people to buy insurance. This becomes coercion. Spouse may not know, but the agent, that lady who is selling insurance, cannot use the power of her spouse to force anybody to buy insurance. This becomes coercion. Coercion is not allowed. The contract becomes not enforceable. If it is established at a later date that the contract was entered into by coercion. The next one is undue influence. It happens many a time. A newly joined employee in the company, let's say the spouse of HR head is insurance agent. Okay. Now this person, this head HR, that is the spouse of that agent, has undue influence on the newly joined employee. By using that undue influence, insurance cannot be sold. If it is established that such undue influence has been used for selling insurance, the contract can be made void. The next thing is fraud. It is simple. It's a kind of misselling or whatever it is. Fraudulently, you cannot misguide a person for entering into a contract. You cannot sell insurance through fraudulent means. It is one of the essential features of the contract. You cannot. The next is misrepresentation or mistake. Misrepresentation is it is simple. You cannot sell a policy that has, say, 10 years policy period as a single premium policy. It is misrepresentation. Right? Even if it is not intended, if the insurance seller makes a mistake and based on that mistake, the insurance buyer takes the insurance, then it becomes void, because it violates this principle of free consent. The buyer of the insurance did not exercise his free consent because of the mistake by the seller. So all these things are common for all contracts, but in case of insurance, there is one special feature pertaining to free consent. That is, because insurance has to follow the Insurance Act 1938. It says no inducement can be offered for buying insurance. That is, you cannot give cash back, you cannot give gifts, free gifts, you cannot give gold coins, you cannot give this, that. All those things cannot be offered for selling insurance. When these things are offered, it amounts to violating the free consent principle of Indian Contract Act, and the contract becomes void when contested. The next essential feature of an agreement for becoming a valid contract is parties competent to contract. That is, both the parties entering into the contract should be competent to enter into a contract. It essentially involves that the parties should be above 18 years of age. That is, a minor cannot enter into a contract. Right? So both the parties should be above 18 years of age. And maybe this is the reason why when parents take policy in the name of child, there is a clause in the policy that says after the child becomes 18 years of age, the policy vests in the name of the child. The policy gets transferred to the child. Right? So, because only after completion of 18 years, the child becomes competent to enter into contract with the insurance company. The next requirement for this competency is sound mind. The person entering into contract should be of sound mind. That is, psychologically he should be fit. He should understand. Simply means that he should understand what he is getting into, what he is signing, and what are the implications, what are his duties as per the contract, what are his benefits under the contract. Understanding of all these things require sound mind. And people who are mentally challenged cannot enter into contract. They are not competent to enter into contract. Okay. Now, other requirement is a person should not be declared illegal for entering into a contract. By law should not prohibit a person. That is, for example, sometimes those people who are punished for stock trading fraud, the regulator says that is, you cannot operate in the market for next 5 years. So when such punishment is given, this person is legally barred from entering into trading contracts. He cannot trade on the stock market. He is not competent now to enter into contract. Lawful consideration is another important feature of an agreement for becoming legally admissible contract. So lawful consideration means the consideration extended by the parties to the other party should not be against public policy, or it should not be for harming any other person. For example, two people cannot enter into a contract for buying fake currency. I cannot say I will give you 1 lakh rupees, you give me 1 lakh rupees of regular currency, and you give me 10 lakh rupees fake currency for that. I mean, such contract is not under lawful consideration. Similarly, I cannot enter into a contract for something like a contract killing. There are people who professional killers, assassins, but I cannot enter into a contract that is legally binding. Okay, so it is for harming some other person. I cannot enter into a contract. The consideration cannot be bringing harm to anybody. Next important feature of an agreement to be a legally enforceable contract is lawful object. That object of the contract. Okay, that means the purpose for which the contract is, the agreement is being entered into should be lawful. So for example, I cannot enter into a contract for distribution of drugs, banned drugs. It's not, the object of contract is not lawful, right? Such contracts are not valid. Similarly, for harming somebody cannot be object of the contract, right? So the object of the contract should be lawful. That is another essential feature of the agreement for becoming a valid contract. The next feature for the agreement to be a legally binding contract is not, the agreement should, the contract should not be legally declared as void. It means what? Simply say there is an organization banned by the government. Let's say like something like a People's War Group, Naxalite. People's War Group is a banned organization. One cannot enter into a contract with the banned organization. Okay. There are so many such organizations banned by the government. So already it is declared as void. It is not lawful for getting into a contract with these organizations. So far we have seen various features as ordained by the Indian Contract Act 1872 for an agreement to be a valid contract in a court of law. Even for insurance contracts, all these features are essential, important. But for insurance contracts, there are two additional features that are not in the Contract Act of 1872. The additional features for this insurance agreements, insurance contract comes because the insurance as a special domain has to follow the Indian Insurance Act 1938. Right? So that there are two important features required for insurance agreement for becoming a valid contract. Number one, insurable interest. Number two, utmost good faith. These two are essential features of an insurance agreement for becoming a valid contract. When we talk about insurable interest, it is not defined specifically in the Insurance Act. Insurable interest over a period of time is, the concept is developed through case laws, through adjudication process. Insurable interest simply means the person who is buying insurance should have a legal relationship with the object of insurance. Suppose that is, when there is some loss to the object of insurance, the person who is taking insurance should suffer financial loss. These two are essential conditions for understanding insurable interest. So, but it is very clear that various people have insurable interest in others based on case laws. So, for example, parents have insurable interest in the children till they attain the age of 18 years. Spouse has insurable interest in the other spouse. That is, husband and wife, they have insurable interest in the lives of each other. Okay? Partners of a partnership firm have insurable interest in the lives of each other. the employer has insurable interest in the employee, okay, and a creditor has insurable interest in the life of debtor, okay. So this insurable interest essentially forms an important aspect of agreement becoming an insurance contract. If at any point of time it is established that the policyholder does not have insurable interest in this object of insurance, then the insurance company will be absolved of its liability to indemnify the policyholder. So it's very essential that insurable interest should be existing at the time of taking the policy, through the policy period, and at the time of making a claim, the insurable interest should exist. And one exception for this is in marine insurance. In marine insurance, insurable interest should exist at the time of claim. That's important. That is, somebody might have taken the policy, or somebody may make a claim. It doesn't matter. But the person who is making the claim should have insurable interest at the time of making claim. So that is the exception, sole exception in insurance as far as insurable interest is concerned. The next important aspect of insurance agreement for becoming a valid contract is utmost good faith. The insurance contracts are declared as contracts of utmost good faith by the Supreme Court through its judgment, right? And what is this utmost good faith means to the insurance contract? Let's see. Before entering into contract, the parties exchange information. Like when you go to buy buy a car or a washing machine or air conditioner, what happens? The seller gives you all the information required to convince you to buy that object. He need not give whatever he knows about the object. He can restrict the information to the extent of convincing you to buy the item. Now it is up to you, under the principle of caveat emptor, as a buyer, it is up to you to ask the pertinent questions, make proper inquiries, and find out what you want to know about the object. So the seller is not obliged to tell unless you ask him questions. This is buyer beware. As a buyer, you have to be careful about what you are making evaluation of the information available, and then ask proper questions, proper inquiries. So this is basically a caveat emptor principle. But in utmost good faith, that is uberrima fides, what happens? The persons, both the parties, will have to give all the information material to the object of insurance voluntarily. Whether asked or not, all the material information has to be given. That is the principle of utmost good faith. If somebody is withholding information that is very vital for the other party in deciding whether to enter into contract or not, and if it is established that such material information was withheld, the contract can be declared as void. So it's very important for people entering into insurance contract to provide all the material information, right, for entering into contract. So for example, when you are buying health insurance, the insurance company cannot find out everything even by medical examination. Everything cannot be established. So you have to declare, suppose you have undergone some surgery some 4 or 5 years back, medical examination may not reveal that you have undergone some surgery. So it is for you to declare to the insurance company upfront that you have undergone such surgery earlier, because it is material for the object of insurance, health insurance. It will decide it will help the insurance company to decide whether to sell insurance or not. If they want to sell the insurance, at what premium they want to sell insurance. This is very important. So similarly, insurance company has to declare all the exemptions, what are not covered by the policy. They have to clearly enunciate, they have to clearly mention. They cannot say, when the claim comes, they cannot say that this is not covered unless they have informed earlier before selling the policy. So this utmost good faith is, the principle is valid for both the parties. So it's very important for both the parties to provide all the material information, as this is an essential feature of the agreement for becoming a legally binding contract. One important feature of insurance contract is about warranties. We have to have an understanding of warranties, because basically an insurance contract need not have warranties. There may not be any warranties, but sometimes there are warranties. But when warranties are introduced into insurance contract, they become very important. That is, a breach of warranty can make the insurance company's liability void. That is, the policy holder, if he does not comply with the warranties, he will not get the benefits. So it's very important to understand warranties as part of insurance contract. Actually, they are not part of essential feature of contract, because they are introduced into the contract by mutual agreement. So for example, let's say when accepting the risk, the insurance company may put a condition, warranty, that the policy holder should have CCTV cameras functioning 24/7 in the premises that has been insured. Now, once this is stated in the contract, it becomes a warranty. The policy holder has to essentially comply with this warranty. If he doesn't comply with this warranty, and insurance company objects at the time of claim that the breach of warranty has happened, so they are not liable, so the policy holder will get into trouble. Okay, so it's very important. The warranties may be like something like maintaining a sufficient number of fire extinguishers. Insurance company may specify the type of fire extinguishers, sprinklers, or the company may specify what type of housekeeping should be maintained. All those things become warranties. It's when the cash being transferred in a van, that armed guard should accompany. All these things become warranties, non-compliance of which may be taken as a breach of contract by the law. So it's very essential for the policy holder to understand what are the warranties in the policy contract, policy mentioned, and comply with the warranties. So with this, we come to an end of this episode regarding the understanding insurance contract. As a recap, essentially we have to consider insurance contract as a normal contract coming under the Indian Contract Act 1872 with additional features such as your insurable interest and utmost good faith. Thank you.